All rise. The Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable Vincent G. Porpy Jr., Chief Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Thank you, Marshal. Good morning and welcome. We've got a criminal case and 2 civil cases on the docket this morning. We'll take the criminal case first. There's 15 minutes per side, and I've put 5 minutes for rebuttal time, but I'll change that depending upon what the appellant tells me they want. And then the civil case will be 20 minutes per side. If you got anything in your pocket that might make noise, will you double check it and make sure that it doesn't make noise? And I'm going to double check mine too, because I don't want to be guilty of violating my own rule. So yeah, mine's off. The panel today, I'm Judge Torpy, as I was introduced already. To my right is the senior member of the panel, Judge Griffin, and about to retire Judge Griffin. And then to my left is Judge Evander, who also is the junior member of the panel. The first case on the docket this morning is Burke versus State. How much time did you want for rebuttal, Ms. Davis?
I'd like to reserve 3 minutes for rebuttal,
3 minutes,
please.
okay. Yes, ma'am, fire away.
May it please the court, my name is Leslie Davis, and I'm here on behalf of the appellant, Gregory Burke. This is an appeal from a final order in a criminal proceeding after a plea of nolo contendere. The trial court suppression rulings were expressly reserved for review at the time Mr. Burke's nolo contendere pleas were entered. In this case, the trial court denied Mr. Burke's initial motion to suppress and then granted the state's motion to strike his second motion to suppress. For 2 reasons, the trial court's order granting the motion to strike should be construed as denying Mr. Burke's motion on the merits. First, the court considered a brief argument on the merits at the hearing before granting the motion to strike. Second, and more importantly, in its answer brief, the state states that the court can consider the trial court's order striking the third motion to suppress as if it was a denial of that motion. The result is the same, since the court allowed the defendant to reserve the matter of the stricken motion for appellate review. Thus, the state has waived any...
Let me ask you this. We're familiar with the facts and the procedure.
Yes, Your Honor.
Let me just kind of try to get to the heart of it a little bit here. Let's just assume, for the sake of argument, that the impoundment of the vehicle was a Fourth Amendment violation. It was a seizure.
Yes, Your Honor.
And also assume that the tow truck driver was not acting as the agent of the police. I understand that you have an argument to the contrary, but just assume that and indulge me for a moment. How do we get from an impoundment being a violation of the Fourth Amendment to the fruits of the subsequent search being excluded?
Your Honor, under Patty, Proctor, and Williams, among many other cases, the impoundment issue is a threshold question under Fourth Amendment jurisprudence.
So are you saying that any time that a vehicle is seized illegally, that any subsequent search that reveals evidence that, as a matter of law, that has to be suppressed?
Yes, Your Honor.
Okay.
It's a fundamental question, and if the seizure itself violates the Fourth Amendment, then any evidence discovered subsequent to that seizure is subject to the exclusionary rule.
So if the defendant's mother had picked up the car at the tow truck driver, from the tow truck driver that night, and she had discovered contraband in it and turned it over to the police, that would be, since the car was impounded improperly, that would be unlawful and it would be suppressed.
Obviously, there's a temporal issue, with your question. So sure, there are situations where the impoundment could be unconstitutional, and yet after a period of time, something else happens. There's a situation where there's a purely private search, purely private discovery that doesn't implicate state action. But in this case, or in a case where you have an improper impoundment and a search that's, basically coincidental with that improper impoundment, or while the car is impounded.
Well, is it a but-for test? In other words, do you think that is it a but-for test? But for the seizure, the evidence would not have been discovered. Is that the test for fruit of the poisonous tree?
The Fourth Amendment jurisprudence simply states that in order to analyze whether or not evidence discovered in a search that's concurrent with or subsequent to an impoundment, that the impoundment has to be analyzed in accordance with appropriate standardized procedures. And if those procedures were not followed, if the impoundment itself violated those standardized procedures, then the impoundment itself violates the Fourth Amendment, and any evidence discovered in conjunction with that impoundment would be inadmissible in state court. I don't know if the courts set forth a but-for test in that regard. I suppose that's true, but for that improper impoundment, that the evidence...
It's a fruit of the poisonous tree issue, isn't it? I mean, you remember fruit of the poisonous tree?
Certainly.
Long Song and all those cases. In other words, the poisonous tree being the unlawful seizure, and then the fruit being what comes from that, right?
I suppose it could be analyzed in that fashion.
Isn't that the only way? Don't you have to analyze every Fourth Amendment problem from the standpoint of whether the conduct of the police at the outset was illegal, whether they made an arrest without a warrant, or they made a search without a warrant, or whether that was illegal, and whether the fruits of that are tainted by that illegal behavior. Isn't that the analysis in every Fourth Amendment case?
I suppose it could be viewed that way. I've not seen the analysis set forth that way. And my understanding, traditionally of the fruit of the poisonous tree doctrine is that evidence is, discovered that is tainted for whatever reason, and then subsequent to that evidence, there's additional evidence that would not have been discovered but for the first evidence, having been improperly discovered.
There you go, using that but for.
What's that?
There you go, using that but for.
Right, Your Honor.
That's why I asked you. Because the law is, since Wong Song, is that it's not a but for test. It has to do with whether the evidence was uncovered as a result of an exploitation of the initial illegality. And it doesn't seem as if that's the case here.
Again, the analysis under the Fourth Amendment starts with that seizure. And the court has to analyze whether the seizure itself comported with the Fourth Amendment, and if it didn't, the evidence has to be suppressed.
Let me ask you about that, about the seizure. Did you all raise the seizure as opposed to the decision to impound? Did you raise that below?
We raised it not as clearly and articulately as we've raised it on appeal, but we raised the issue. We attempted to raise the issue of the policy that applied to the officer in this case.
Yeah, but that was in regard to that the officer was supposed to do an inventory search.
Well, what we argued was that the officer was required to do the inventory search in towing the vehicle.
Right.
So we did make the argument, we didn't clarify it the way we've clarified it on appeal, but we did make the argument that under that policy, the officer was required to do the inventory search in order to tow the vehicle, in order to impound the vehicle. We cited Patty, we cited some other authority for the proposition that both the seizure as well as the search have to comport with the Fourth Amendment.
Well, I understand using the word clarification here, but it seems to me that the trial judge below did not hear anything, and there was nothing in the motion about whether the decision to impound the car, not whether the inventory afterwards, but the decision to impound the car was improper and violated the policy. It doesn't seem, if you can point out a place in the motion, the record where that was raised below, Again, it's not the decision to impound the vehicle that we are
taking issue with, it's the procedure that was used in impounding the vehicle. So the officer may have had a perfectly good reason to impound the vehicle. We would argue that he did not in this case.
Yeah, but the decision to do that was not raised below.
The decision, that decision is not our argument.
Okay.
It's the procedure that was used in impounding the vehicle. Once that decision was made.
All right, but the problem I have with that is your preference that the police officer have fully inventoried rather than the tow truck company, and would that mean that he would then find the contraband instead of the tow truck driver?
Our argument is that had this been done properly, he would not have found the contraband. If this inventory procedure had been performed in accordance with the policy that was required to be followed, any valuables would have been removed and stored, and inventory would have been taken, but the camera would not have been turned on and viewed, the drives would not have been put into a computer and viewed, but the computer would have not been turned on and searched. The search itself, as done by the tow truck driver, did not comport with the policy. It was not reasonable under the Fourth Amendment. So yes, if things had been done the way they were required to have been done under this policy, then the car would have been towed, it would have been...
All right, but if the seizure is lawful, and so the police officer does his inventory search and doesn't find any contraband, doesn't turn on the equipment, but then he delivers it to the tow truck company, then without any further instructions, would they turn on the camera? Then is there any link between the police officer's failure to do an inventory?
There is a link, because if there were any valuables, and I would argue that, camera would be a valuable, that they had to be removed and kept for safekeeping. Only items that are clearly not subject to being stolen, being, gone missing, that would be valuable. As you know, the policy behind the inventory search is to protect the driver's possessions. It's to protect the police from arguments or claims that the property has been stolen or damaged, and it's to protect the police from dangerous...
That's the inventory policy.
Right.
What is the Fourth Amendment policy for restricting searches in the inventory context? What is the Fourth Amendment policy?
The Fourth Amendment is a reasonableness policy.
What's the policy behind this whole body of law that relates to inventory searches?
Basically, they're not done in conjunction with suspected criminal activity. So they can't be done as a subterfuge for looking for evidence when there's a suspicion.
Right, that's the policy, to avoid pretextual use of an inventory under the caretaker function as a way to get at...
Correct.
To search the car, right?
Correct. But the Fourth Amendment is uncomfortable with the notion of inventory searches, because
Right.
they are administrative, yet there are privacy interests, and the policies behind those excuse me, searches are not met when a police officer goes and looks, unless there's a written policy that gives that police officer certain criteria to use in terms of open and closed containers.
But the evil that the Fourth Amendment is concerned with is the use by the police of the inventory search as a pretext when they don't have any other valid basis for a search. That's the evil, right?
That is one of them. I would say the Fourth Amendment is also concerned, overall, the overarching concern of the Fourth Amendment is people's privacy interests. Whether it's a car, whether it's a house, whatever it is, people have privacy interests. And as you know, the Florida Constitution protects those privacy interests to a greater extent than the federal Constitution. And I would say that anybody in a car who has a camera or a drive or some sort of digitally captured information has a reasonable expectation that if that car is impounded for some reason, that a police officer is not going to go in and start looking through that camera, start plugging those drives into a computer, opening up the computer and looking through files.
What purpose under the prevailing law as it relates to the exclusionary rule, like the case of Herrera, which was a very recent case in the United States Supreme Court, there's always, the purpose for the exclusionary rule is to deter police from improper behavior. In this case, where there was no search conducted by the police officer, what deterrent effect would the exclusion of the evidence have?
The exclusion of the evidence, here's the situation. This police officer decided to have this vehicle towed when it was parked legally in a 24-hour business area, no hazard to, the public. Decided to have this car towed by someone who later turned out to be a convicted felon. Knew...
Are you getting a little astray here?
I understand.
Well, you're running out of time, so...
I am.
Just get to my question, if you can. I mean, the tow truck driver being a convicted felon is really irrelevant to my question. So.
Well, I think that the idea of the Fourth Amendment, though, is not just, it's to protect against unreasonable searches, unreasonable seizures. In this case, I don't think it could be reasonable for the police to take someone's car, send it away with a tow truck driver who happened to be, could have been a convicted felon with all its possessions, and know that car is subject to search, to removal of evidence, to removal of property.
Okay, you're almost out of time. I'll give you another minute if you conclude right now. You want some rebuttal time, right?
I do.
Okay, I'll give you another minute of rebuttal time, all right?
Okay, I appreciate that.
Right.
Thank you.
Yes, ma'am.
May it please the court. I'm Rebecca Wall, Assistant Attorney General representing the state in this appeal. While I absolutely agree that the Fourth Amendment, the thrust of the Fourth Amendment is to protect the privacy interests of individuals against unreasonable searches and seizures, as Judge Torpy points out, the purpose underlying the exclusionary rule is to deter unlawful police activity. The argument that the police officer failed to comply with procedural rules needs to be punished by the exclusionary rule just doesn't comport with what the whole thrust of the exclusionary rule is. There was failure to comply with whatever the rules and regulations by the police department did not make the officer's activity illegal activity. It's clear that the actions of the tow truck operator were done completely and solely because his boss, his company required it. Had nothing to do with the police officer.
Is there any evidence in this record that the policeman that made the decision to seize the car was aware that the tow truck company would perform a search?
No, and usually, of course, when the state receives a reply brief, of course, we don't have the opportunity to reply to a reply brief, and it's nice to have the opportunity to. I think in the reply brief, you'll see that...
It's like Mason and Dixon, we have to draw the line somewhere.
Well, exactly, and especially with lawyers who would go on and on and on. However, in this particular case, I think if you look at the reply brief, counsel pointed to several locations in the record to support the assertion that the police officer did in fact know exactly what Mr. Didion was going to do, and I absolutely disagree with their assertion. If you look at the record where they point to support their claim that the driver knew what the tow truck company would do, they cite to the operator's deposition. And the actual questioning went, question, what instructions did you give to the tow truck driver? The operator answered, the officer answered, I didn't give any instructions to the tow truck driver. Question, is that just something that's understood what he's going to do? That is the crux of what they claim, shows that he knew. The officer went on to say, yes, the only instructions I have listed on the tow sheet are released to owner. Basically what that indicates is there's not a hold on the vehicle, there's no need to hold the vehicle. My standard procedure is they come pick up the vehicle and then they just hold it until the vehicle owner can take back his vehicle. That's the sum total of what they point to show that Officer Huckabee knew exactly what Kendall Towing and Mr. Didion was going to do, and that the record just doesn't support that claim. In fact, the officer didn't, he says they work with so many tow truck companies, he doesn't know what the policies were, and more importantly, if you look at the record, It's very clear from everything the officer said, he had no interest in the car or the contents of the car. He arrested the defendant simply because there was an active warrant, and he basically had no choice. He saw that the contents of the car were so overwhelming, the defendant had either been living in his car or he had moved all of his belongings from Alaska, but everybody agreed there was so much stuff in the car that the officer faced hours of detailed inventory. If he chose to do any, if he had any interest, he certainly...
It was the antithesis of a pretextual
Absolutely.
seizure.
Absolutely, he had no interest. And if he had wanted to, he had an excuse by an inventory seizure, but he had no interest in that vehicle. He said release to owner, and if the defendant had been able to get back to the tow yard by bonding out or whatever before the tow truck operator got there, he would have gotten his vehicle back. So there was no link between the arrest of the defendant and the vehicle. And that was very clear throughout the record. So I think when you look at the purpose of the exclusionary rule, to deter illegal activity by the police, there certainly was no illegal activity, even if the decision, and I would argue the police had the discretion to decide whether or not to have the car towed to protect the vehicle and its contents. But so there was no abuse of discretion by the police officer, and even if there had been an abuse of discretion, there certainly was an absolute disconnect between the actions of the officer and what Mr. Didion did. And based on the record, it's clear that the trial court made a factual determination, supported by the evidence, that there was no police action here, it was a citizen search. And unless there are any other questions, the state asks that you affirm the judgment and sentence in this case.
Okay, thank you. I meant Herring versus United States, not Herrera. When I said Herrera before, I was talking about Herring. Okay, just a second, and let me add some more time to the, well, you can go a minute over. You got 15 seconds left. You can go a minute over.
Thank you,
Even
Your
though
Honor.
Ms. Wall didn't use near all her time. I'll give you some of her time.
Thank you, I
right?
appreciate that.
Okay.
The state cites some cases that involve private actors searching that clearly demonstrate that the Fourth Amendment is not implicated. This is not one of those cases. This is in the gray area in terms of the search, aside from the improper impoundment of the vehicle. This is one of those gray areas where it's not clearly private, it's not necessarily clearly governmental action.
You say improper impoundment, but that issue is not raised below, so don't we have to assume that it's proper?
I would argue that we did raise the issue below.
Well,
and-
you raised that the inventory search after the decision to impound the car was improper. Not the-
Actually, what we argued was that the officer did not follow the policy, and that policy requires a search in order to tow and impound the car. So I would argue that we did...
But to get into the car first, he has to make the decision to impound it.
But it's not the decision to impound that's the issue, it's the procedure of impounding that's the issue. And he's required to follow the written policy for towing and impoundment, and he didn't do so. And we did raise that argument, not as articulately as we could have.
He would not have done as thorough a search as the private party did.
He would not have gone into closed containers, cameras, hard drives. That would not have been reasonable. There's an expectation of privacy that would have been,
If he would
that
not
would have
have gone
overridden.
into
If he
it-
had, it would not have been a reasonable
But if
search.
he would not have gone into it and the tow truck driver did, doesn't that suggest even more so an independent act of the tow truck driver?
No, Your Honor, because anything of value, the officer would have had to gather and keep at the station. So there would have been no camera in the car.
Well, what is anything of
arguably,
value?
that would have-
What is anything of value? Does that mean you'd have to take everything out of the car?
Not everything, no, sir. But certainly anything that arguably is of value. So a computer and a digital camera, I would,
Well, he wouldn't be obligated to take the camera out. Wouldn't that be a discretionary call?
it's discretionary, I suppose, in terms of what is of value, but now we're talking about, a hypothetical that we can't answer because that didn't happen. But certainly it could have, he could have removed, should have removed the camera,
You gave her
the computer.
a minute over the extra minute I gave her. Is that? Okay. All right, thank you, counsel. That concludes your...
Thank you very much.
Yes, ma'am.